So the Real Estate Commission, Mr. Bill Davis talked to us yesterday about some updates from the Real Estate Commission and what they're working on. I just grabbed their agenda from Monday's meeting. I wasn't able to make it because I was preparing for things for the conference. But these are some of the things that they will be discussing at upcoming meetings. If you're interested and you want to come to a meeting and weigh in on them. So consider allowing associate brokers to earn continuing ed for QB refresher course. The course is currently required of QBs as a condition of license renewal or restatement of their qualifying broker license. However, because the course is a QB requirement as opposed to a continuing ed requirement, there's no license, there's no credit available. Resolve ambiguities in the transaction coordinator role. Oh, there's a lot of those, huh? Yeah, the transaction coordinators are a complicated issue, and I think one of the main things, one of the big things we need is probably some clarity on what requires a license in the realm of transaction coordinators. Right now, all we have is, the general definition of brokers. This is what if you're doing any of these things, you've got to have a broker's license, right? And then we also have our unlicensed assistants. We have prohibited and permitted activities under those rules, but a lot of those don't really apply to what transaction coordinators are doing. And so we don't have a whole lot of guidance because we do have TCs that are licensed and TCs that aren't licensed and TCs that are ABs and TCs that are QBs. So I think that they're looking at all of that and clearing that up, so that's great news. Review and revise the qualifying broker supervisory requirements. Move seller and buyer broker disclosure language from the real estate advertising rule to the brokerage relationship and broker duty rule. Amend the definition of property management to cover brokers managing homeowners associations. I was wondering if that was on there, and it is. There's a lot of confusion on that, whether or not HOA management companies fall under the licensing rules or they don't. Some HOA management companies have brokers who are handling their stuff, and some don't. So we really need some clarity as to whether or not they have to have one or don't have to have one. So I'm thrilled to see that out there. Thank you so much. Define the term residential in the context of residential property management. Consider a rule change allowing brokers to carry over continuing ed credits to subsequent licensing cycle. That's cool, yeah. Adding language that would close a loophole in Part 13 that currently allows brokers to earn continuing education credit for attending their own disciplinary hearing.
Let's start kind of figure that out.
I'm saying the core instructors can't get their core instructor credit for teaching the core instructor, but evidently you can get CE credit for attending your own disciplinary hearing. That's rich, isn't it? That's rich, yeah. Well, the realtor, obviously the commissioner saw how ridiculous that was too, so they're going to fix that. That's nice. Restore previously existing language to Part 19 that require written disclosure to all brokers involved in transactions where there's a limited service broker on the other side. So requiring a listing broker in a limited service situation to disclose the fact that that's the case. That's what we put back in. I think that got removed kind of accidentally in some of it wasn't intentional. I don't recall it ever being intentional. Remove language from Part 19 that requires brokers to disclose all written agreements that a broker has or a brokerage has in the transaction. So as you guys recall, at my legal update a year ago, when I was talking about this new rule, and people would call me and ask me, well, what does that mean, Ashley? And I said, I don't know what it means. And over the years, I don't know what it means. Because what happened when they were doing the rule, and it was unintentional, what they did when they were doing the rule is they said, you have to disclose all written agreements. And then they say, kind of including but not limited to, and they said transaction coordinator agreements, right? Or they said all written agreements, but then they specifically listed transaction coordinator agreements. Well, just the way rules are typically interpreted. If you already list the specific agreement that you intended to include, then when you look at this language, other written agreements, you must not be talking about that language, right? The TC agreements, because you've already listed that. It was unnecessary to say other written agreements because you specifically listed transaction coordinator agreements, which we already established you must disclose. Right, transaction coordinator agreements or licensed transaction coordinators involved in the transaction. That was part of the rule. So people would ask me, what does that language mean? And I'm not sure exactly what else they intended to include in that. And so somebody asked me about referral agreements because over the years I've gotten calls, quite a few calls over the years where consumers have found out that you guys are paying referral fees to somebody, but they don't find out about it until after the fact. And then they're not happy about it for whatever reason. They felt like they should have known about that, right? So the broker calls me and says, did I do something wrong? I didn't disclose this referral agreement to my consumer. And my position has always been, there's really nothing in the rules that requires you to disclose that. So no, I mean, the consumer might have felt like they were entitled to know that, but there really isn't anything in the rules that requires you to disclose it. So then this language came out and the question was posed to me, and I said, yeah, it could mean that. It could mean written agreement, it could be a referral agreement you have in the transaction. And so when I said that at my legal update, it was brought to my attention that that was not the intent of that language. And I said, oh, okay, well, I mean, intent, or not, it could that be, used that way against you guys? Let's find out. I called with the real estate commission, and he said, I don't know what that means. And I said, okay, well, tell me this way. If a consumer called you and filed a complaint against a broker because they failed to disclose a referral agreement that they had in the transaction, would you summarily dismiss that? Would you tell them, I'm not taking your call, I'm not taking your complaint, that's not what that language means, and therefore we're not going to pay, I'm not going to create a complaint from this? And he said, well, heck no, I can't say that. I'm going to take the complaint, and it's going to go through the process, and the real estate commissioners are going to have to decide what that language means. And I said, well, if that's your position, if you're not telling me it's just not going to go away magically, and you're going to put the brokers through that, then I'm going to tell the brokers they have to disclose the referral agreements until you guys fix this. So if they take it back out again, there's really, again, we're back to there's really no language that requires the disclosure of referral agreements. And so that'll be an interesting discussion at the commission, because I know that some of the brokers don't like the idea of disclosing that, but you guys have to remember, no matter how this plays out at the commission, and don't be down on the commissioners. The commissioners have a different job, right? I mean, their job is not just to protect you guys, their job is to protect the consumers. So if they ultimately feel like the consumers are entitled to know that, then maybe they'll get rid of it, maybe they'll reword it, but you guys have to always remember with the commissioners that they have a different perspective. It's not just all about you. They have to watch out for the public. That's what their charge is, right? That's what their duties are. So cut them some slack. So maybe they'll get rid of it completely, and we don't have to disclose it. We'll just have to see how that plays out. What the rule language would look like if the salesperson exam were substituted for the broker exam as the entry-level exam for associate broker candidates in Part 3. I'd have to go back and, I'm not real clear on that either. I'm going to have to go back and look at that. Language that would require property managers to take the Uniform Resident Relations Act only once upon the execution of a property management declaration instead of during every 3-year cycle renewal period. Okay. Well, it could change. It very well could change, and I think to take it one time in a lifetime of a property management, I don't know. Again, if that's in the best interest of everybody. But you guys will have your say. You can go in and tell them what you think of that idea. A rule change that would amend Part 13 to expand from 10 hours to 12 hours the continuing education credit that an improved instructor can earn by teaching commission-approved courses. Expanded from 10 to 12 hours. And this change would take into account those approved core instructors who teach the 4-hour core course at least 3 times during the renewal cycle. Clarifying that supervisory affidavit for QBs is actually an acknowledgement of the QB responsibilities, including the supervisory responsibilities in Part 3, and adding language to Part 32 to require that a broker buying property for their own portfolio disclose that they are a broker. Yeah. So unless I said it, it's not necessarily a bad thing just to tell them you're a broker. Just remember that it's all kind of